Dementia is just a fact of life these days. I think the Alzheimer's Association did a study a couple years ago that determined that 1 in 3 seniors now dies with some form of dementia. So I expected to see it on many of my cases and did see it. I know that it's not a reason to drop a case, and I think if you're in an elder abuse unit or you're just a new prosecutor starting out on these cases, you shouldn't just drop the case because the victim has some degree of dementia. I once in a while saw cases reduced from felonies to misdemeanors if the victim had dementia, which I would encourage prosecutors to ask a lot of questions. Folks who have dementia need to be protected, and if they are abused physically, sexually, or financially, their cases need to be prosecuted. And it will sometimes be more challenging to prosecute that case, but oftentimes I think it could be less of a challenge to prosecute that case, because if you have a victim that is especially seriously impaired and they are abused or exploited, all you do is present the evidence about their mental condition through various witnesses and go forward with your case. I have found that the juries tend to be outraged and they do the right thing. So for a new prosecutor handling an elder abuse case with a victim with dementia, it may seem to be really overwhelming, but I would suggest that after talking to witnesses like the victim's doctors, nurses, who can say, yes, she used to be able to carry on a conversation. Now she can't even put 2 sentences together. You can prove your case in many different ways. That these cases can be proven beyond a reasonable doubt, and that they can be incredibly rewarding.
Of what importance would it be for a prosecutor to evaluate not only the facts of what happened, but also things like capacity, competence, ability to consent?
Some older witnesses, as I said, will be fine. Talk to the folks who live with them and talk to their doctors especially, and you'll learn that they're really doing pretty well, just about as well or even better than some younger adults. And we treat those cases in a similar way as we do with younger adults. Other witnesses have certain challenges. Just because a witness has been diagnosed with a dementia like Alzheimer's disease does not mean that they're not able to testify about an event or a transfer. And it's important to talk to witnesses about the degree of that dementia and investigate the case accordingly. I think it's most important to do that research really quickly so you know your victim and not to jump to any conclusions. And of course, just like in all domestic violence cases, we build our case as though the victim will not be a witness. I won't say won't be able to testify, because some of our older witnesses, our older victims, are very reluctant to testify against their kids and their younger relatives. Others who have dementia, the dementia will be worse by the time the case goes to trial. And of course, some of our victims who are older will have passed away. So we always build our case as though the victim will not be available to testify.
There's a lot of things to consider when a victim has dementia. First of all, I have to say that as a prosecutor, I want to make sure that just seeing that notation in a report that there actually is dementia. Sometimes what we'll see is we'll get police reports where an officer has made an assumption that a victim has dementia, and it's really, when I do training for law enforcement, I have to really caution them not to make that note in their report unless they really know that there's in fact a diagnosis. Simply being told that by a family member or making that assumption just based on the victim's demeanor at the scene combined with their age it can be really dangerous to write that in the report, because it can really have an impact on the case. So first of all, I want to know if they actually have that diagnosis. If that's in fact the case, that's not the end of the story. But like any other case where we don't have the victim, in a homicide case, for example, That's not the end of the story, the fact that we don't have the ability to involve the victim or use the victim's testimony in the case. It's really important for prosecutors to just take a comprehensive look at the evidence that you have, look at the 911 calls, the medical reports, any victim statements, anything that you have, anything that can tell the story without the victim getting up and being able to testify. That's how I analyze the case, really is not so much whether I have the victim's ability to participate, but whether the evidence is there to prove the case with or without her.
In many of our sexual assault cases, the defense is going to be consent. We have, in the course of prosecuting these cases, tried to find ways in order to show for the jury and let the jury know exactly what the cognitive impairment of our victim was at the time that these crimes were committed. One way in which we have done that is to take a deposition. So actually have a hearing that's videotaped, that's recorded, where our victim we can capture the moment of the crime for our victim and also for the jury to see later. We've also had cases where our victim has had severe cognitive impairment and yet the defense is still consent. And in those cases, we've had our law enforcement go out, for instance, to a nursing home and set up a videotape to interview our victim, and actually done that interview where our victim is attempting to respond to the law enforcement officer's questions, but not really able to answer the questions because of that cognitive impairment. And the ability to capture that on video and then play it for the jury is what has helped us defeat many of the claims of consent in these cases.
I realize that a prosecutor can't interfere with a juror's deliberations, but have you ever received feedback or information or commentary from jurors about the impact of that sort of information on their decision?
Jurors have told us in many of these cases, I can think of one where the deciding factor to them was actually seeing a videotape of our victim and her ability or inability to actually talk about issues that weren't even related to the crime, but that showed her cognitive impairment at the time. And that, they said, was the best evidence for being able to defeat the defense of consent.
Are there any difficulties with admitting those, with obtaining them in the first instance? How does that work for a prosecutor?
So when we ask law enforcement to go take a video of our victim in our sexual assault cases in order to try and defeat that consent defense, because it's a part of the investigation, the law enforcement officer is able to go and take that, and what we have found is people are very willing to facilitate the ability to take that. So prosecutors should feel free to explore that idea. The way we are able to get those videos in is because they are not videos about the crime itself. It's a video that establishes what the state of mind of our victim is at the time of the incident or at the time of the sexual assault. So the questions that we have our law enforcement ask are things about orientation to time, place, who the president is, or what they have watched on TV. And if it's a victim that has significant cognitive impairment, those are difficult questions to respond to accurately. And it is that type of response that really isn't going to the truth of the matter of the case before the jury, but it really goes to what is the state of mind of our victim at the time of the crime.
Is there other information or proof, evidence that you would gather related to someone's capacity?
In our sexual assault cases against elders, we typically have not only a video, but we would collect medical records that go back and are able to identify when some incapacity may have started, dementia may have begun, also what medications the individual victim is on. Those things are all very important for the jury to hear, that this isn't something that we are arguing just to them, but it is something that our victim has lived with and this progression has occurred over time.
If there is an issue with capacity, then we'll work on getting maybe a search warrant to get the medical records. If I'm going to argue to a judge and to a jury lack of capacity, that this person didn't have the ability to give consent, and I find that my detective went to the victim's home and got the victim to sign a medical release form, which is you look at it, it's a pretty complex legal document in itself, then I'm going to have issues and problems later down the line. I've got to have a search warrant done instead. So it's very important that early on we assess capacity issues and then work with law enforcement to make sure we don't fall into a hole which otherwise the defense will exploit fully at trial.